All right, welcome everyone, both offline and online, to this roundtable discussion following a very interesting almost 2 days. So what we've done over the past day and a half during this workshop is we've brought together a group of climate scientists, a group of international lawyers, to just talk about a climate case before the International Court of Justice. So what would such a case look like, and what would be potential obstacles, possibilities, both from a legal perspective and a scientific perspective, comparing concepts, terminologies, etc. So we've had a very rich discussions. Clearly, we do not have definitive answers yet, but we've jointly formulated many questions that can inform future interdisciplinary collaboration. And we wanted, through this roundtable, also to give all of you a bit of a taste of the things that were discussed. No complete overview can be given, but we will try to tease out a bit of the interesting discussion points, and also leave quite some time at the end for questions from the audience, discussion with the audience, both online and offline. So the individuals on stage here, which I will introduce soon, they've kindly agreed to play a more prominent role in discussions, but most of us that were here for the workshop are in the audience today as well, so they can chime in whenever they feel like it. So discussions will not necessarily be led by me, they will be led by three promising rising stars. So we have Sophie Friederike, she's a colleague at the Amsterdam Center for International Law, and is finishing her PhD on the power of procedure before international courts. Then we have Philip Sauter from the Max Planck Institute, who has a dual background in law and science and is working on the legal framework of nuclear fusion. And finally, we have Rosa Pietrojusti. She's from the Vrije Universiteit Brussel, and she has recently started, I think, her PhD on how climate science can support youth-led climate litigation. So thank you very much for taking on that role. Before giving Sophie in particular as a first discussion leader the floor, let me introduce the people on stage. So directly next to me, Professor Joeri Rogelj, and he's a professor in climate science and policy at the Center for Environmental Policy, Imperial College, and director of research at the Grantham Institute. Also, amongst many things, a lead IPCC author, as well as a member of the European Scientific Advisory Board on Climate Change, which we will talk about also during this roundtable. Next to him is Professor André Nollkaemper, Professor of Public International Law and Dean of the University of Amsterdam, an expert amongst others in questions of shared responsibility in international law. Then we have Dr. Friederike Otto, and she is a senior lecturer in climate science at the Grantham Institute for Climate Change and the Environment, IPCC lead author, and amongst others, co-lead of World Weather Attribution. And finally, on my far right, Dr. Katalin Sulyok, assistant professor at ELTE Law School in Budapest, also head of department at the Office of the Ombudsman for Future Generations in Hungary, and author of a very relevant book for what we're discussing today, entitled Science and Judicial Reasoning. So with that, I hand over the floor to Sophie.
And if we turn around, I think that's easier. Thanks so much for that kind introduction, Natasha. Hi, everybody, welcome. This has been a great opportunity for me, and I think to speak on all the rapporteurs of Rising Stars, as you call them. I like that title. That our mind has been blown on several occasions. We're equally exhausted and inspired by this workshop, and I think many good things will come from this. So how we wanted to structure our interventions now is really taking this starting point of what would happen if we would bring a case before the International Court of Justice. And why is that special? Is because it would be a kind of case between two states, or potentially more states, which, all the other climate litigation so far, domestically or before European courts have not exactly dealt with. So we're talking on a different scale. We're also talking about the International Court of Justice being kind of the leading institution and court from which a lot of obligations trickle down in international law. So that's kind of the reason why we're doing that. And then we were thinking, okay, what do we need? What are kind of the obstacles, both legally and scientifically, and why we all come together? And then there are three broad strokes of interventions, but it's definitely not meant to be limiting, but just as a hook for all of you to maybe latch on or whatever questions you might have. So first, we were thinking, okay, if we need to bring this kind of case, some kind of harm needs to be connected to the state and the action of the state. So attributing some kind of harm, something that happens to the responsibility of the state. And this brings legal questions and definitely also scientific questions, like how do we do that? How does that link work? So we have discussed uncertainty, probabilities, discussion on evidence. So these are kind of all the issues that come under that. And the second thing we need to define is, well, there needs to be breach of an international legal obligation. So secondly, what is that obligation that we bring before court? I think there's two main things that we've identified over the past days. We bring it under the no harm principle, broadly understood, and everything that comes with that. And then immediately this question, what is harm? And it doesn't mean the same thing in law, in science. It was significant harm. So there's been another of these issues that we need to tease out that are super interesting. And second, we talked a lot about the Paris Agreement and what are the obligations there, and how has science translated them or implemented them into the agreement, and how have lawyers understood it. And we see some really interesting synergies and some differences that can be resolved. And then the third part is, okay, we can attribute it. We have a breach of an international obligation. What do we actually want from states? What is the outcome? What do states need to do to respond to this? They need to change their behavior. Is that mitigation, adaptation, reparations, all these kind of questions, and how do we calculate that? What does that look like? What would be ideal? And again, here, legal questions as well as scientific questions are super important. So this is kind of the broad framework and the three broad strokes that we identified for this discussion, and feel free to latch on and add on anything you like. And the three of us will be asking questions, and I'll pose the kind of preliminary questions to Kata, because you have in your work already engaged a lot, and in your book, with the role of scientific evidence and science in international adjudication. So in your experience, what is really the role? So, maybe preliminary for everyone, like, do we need the science? We think yes. Why? Where does it come in? At what stages? And I think we can observe a kind of reluctance of judges, especially at the International Court of Justice, to engage with these kind of questions. From your experience, why do you think that is? And from your experience, as well as the discussions, could you identify ways to respond to that in a meaningful strategic way? So let's start with that.
Thank you so much for the starting question. So good afternoon, everyone. So starting with the role of science in scientific adjudication, climate adjudication specifically. So my research concerned the environmental case practice of international fora, and so I looked at specifically the environmental case practice of the ICG, the PCA, the ITLAS, the regional human rights courts, WTO. So based on my research, I found that even though science plays and should play a major role in all these disputes, unfortunately, international courts try to circumvent it in many ways, even though environmental disputes and climate disputes, arguably even more so, they are infinitely closely connected to scientific facts. So all our legal concepts in climate law cannot be really operationalized and interpreted and applied without having recourse to scientific evidence. But we see that this will be, and this is a real and huge challenge for international jurisdictions. So in my research, I propose that the science really transforms the whole process of the adjudicatory process, like the framing of disputes, the causal inquiry, the scientific fact-finding, and the standard of review. Basically, these are the four main sort of points of intervention where I think that science should and could transform, or will inevitably transform, the adjudicative process. We also see, as I've mentioned, that international courts try to not to integrate or reflect on science very closely in their decisions. And I think that there are some major challenges along the way, which may explain this phenomenon. The first is that science is present in the courtroom as a sort of extra-legal cognitive authority, in which judges lack the requisite epistemic competence. So international judges, of course, do not have a scientific expertise, but science has a very strong cognitive authority. And due to the fact that international courts are not experts in these technical questions, they may be intimidated of really understanding these issues, because international courts and judges in general are vested with the power of interpreting the law as they deem fit, but the scientific facts are not at their full disposal. So in a way, the presence of science challenges the decision-making authority or discretion of international courts or courts in general. So this may be one of the explaining factors why it's so hard for courts to engage with these highly technical issues, because in order to do that legitimately, they first need to really understand these highly complex matters. And there's another layer of challenges, in my view, which I usually call doctrinal challenges, which stems in these sort of structural differences between the methods and vocabulary of the two fields. So scientists and lawyers tend to have radically different views on causation, what the requisite causal link is, how we establish it, how we prove it, what a persuasive evidence would look like. The two sorts of inquiry realms have different methods of persuasion. Lawyers would like to receive certainties and binary answers, whereas scientists cannot provide. So they speak in the language of probabilities, and scientific uncertainty is pervasive in the sciences. So that sort of the third main differences between these two types of realms that hinder the cooperation of scientists and lawyers in the courtroom, in my view, is the sort of their different tolerance towards uncertainty. So whereas scientific uncertainty is treated as a totally normal and ubiquitous phenomenon in scientific research, uncertainty poses a real obstacle in the courtroom for lawyers to establish legal relevant causal links. Yeah.
Yeah, no, thank you so much. I mean, I just want to quickly follow up and open to the rest of the panel on that. So you identified two big challenges, how I understand. One is the scientific uncertainty that courts are reluctant to deal with because they want a yes or no answer. But I feel like over the past 2 days, we've kind of managed to talk to each other and understand that this is not actually the case, and the fear might be not so well founded. And the second fear being like, well, scientists will make the judgment calls, and what are we doing then as judges? Our authority is taken away. And I also feel like, or at least for me, I feel like this fear is not as real as we thought it was. So I'd like to hear from maybe also the other panelists how you respond, especially the scientists on the panel, how you would respond to that.
So I think if I just start, we have talked a lot about uncertainty, and of course, when you read a scientific paper and we quantify a harm, then you always have it presented with a confidence interval and statistics. But you do not have to frame questions in this way, and you don't have to quantify harm in that way. We have actually identified, and I think that will be one of the outputs hopefully of this workshop, that there are a lot of things we have certainty. We know that because of the burning of fossil fuels and the temperature of the atmosphere increases, we know that at the same level as we know that the Earth is not flat. And similarly, at the same level, we know that this increase in global temperature caused by burning of fossil fuels has led to an increase in extreme heat everywhere in the world, and heat waves are more frequent and hotter. And we also know that without any doubt that heat waves lead to casualties and increased mortality. So that's just one example where we actually have a causal chain that we can frame in a way without ever talking about uncertainty, but it's just, of course, as soon as you try and quantify something, because every measurement has always uncertainty around it. That's just how science works. Of course, you then have uncertainty, but you do not need to quantify things to demonstrate that harm has been done to people, to populations, and also who has caused harm.
I think this leads very well onto the question by Friederike, which continue on this. So your main research focus has been on climate change attribution and extreme event attribution in particular, and you have also collaborated in research with lawyers and have researched and collaborated in research on how current climate litigation might be underutilizing state-of-the-art in climate science and attribution science in particular. Could you tell us about these advances and how you think this can help us frame this question in a way that that can address the issue we were just speaking about? And also, as a second point, are there sometimes misunderstandings in how some of these questions are translating from climate science to legal practitioners and legal scholars, which influence how you then frame the answer, well, which we need to reflect about. And also, how does this influence the way, how does this and the importance that, for example, what weather attribution has given to communicating to the general public, how does this influence how you frame and put in context the research period?
Okay, that's a lot of questions. I'll try to just give a brief answer to hopefully cover some of that. So what we do in extreme event attribution and in weather attribution is to answer the question whether and to what extent human-induced climate change, so climate change induced by the burning of fossil fuels, has played a role in extreme weather events. So made a heat wave hotter or a cold wave less cold, or changed the likelihood of a heavy rainfall to occur. And so you can, of course, frame this in a very, very scientific, statistical way, where you can say, so this the rainfall that led to flooding in the north of the UK associated with Storm Desmond has been made 2 to 5 times more likely, or 5 to 80% more intense, or something, which for a scientist is a very neat result and is actually something where you have a lot of confidence in. But for a lawyer, that sounds like we don't know nothing because there are all these numbers. But of course, you can, as I already said, you can frame that in a way that, well, we know that climate change has made this event more likely, and we know also it's not been a complete game changer. So it's not been made 100 times more likely or orders of magnitude more likely, but we know it played a role, but not the only role, and there are other important factors. So I think that's one thing where it's really just how can you translate your numbers into something that makes sense for someone who is not familiar with statistics. And that is actually something that can be easily done, but it's not something that scientists routinely do. And I think it is one of the really important things that we as scientists can do and have to do also to help with climate litigation, but also just with understanding of what we know and what we don't know more general, is to do this translation and to talk about this in the media, to lawyers, to everyone in a way that is understandable. Because to answer the first part of your question, my experience with lawyers and how science is underutilized. So what we found looking at cases, in particular damage claims, is that most of the claims that have been brought to court were for events or for harms that are actually extremely hard to attribute. So that are regions of the world where we have very little data, or for types of extreme events where the role of climate change is quite small. So something like droughts or hurricanes or other tropical cyclones, where especially in the North Atlantic, we don't have that much data, and it's hard to say with certainty that there is an influence. Whereas there are, of course, other events in other parts of the world, and not limited to the global North, where we can say with certainty that there was a harm and that was caused by climate change. But this knowledge that we can attribute individual extreme events to climate change, but that this attribution is not the same for all types of extreme events and for all regions of the world, is of secret knowledge to the scientific community at the moment. It's not something that is known generally in the general public. And therefore, of course, because most lawyers and judges are not scientists, have the same kind of knowledge as the general public, more or less, also not in courtrooms. And that's why this communication aspect is so important. I've forgotten, there was another part of your question, but hopefully we can come back to that.
Thank you. Yeah, thank you so much. I mean, this ties into, so we really work on attribution, that we can attribute these things to climate change. And well, I think we all know climate change states, amongst others, and other actors are responsible for that. So question for you, André, is you worked a lot about shared responsibility of states and also other types of actors. And I think one of the main challenges that we have for bringing a climate case is that, well, whose fault is it? Everybody's. And then in law, we struggle to deal with this shared responsibility. So do you think, well, first, could this challenge be overcome? For example, in the context of bringing a climate case before the International Court of Justice, and how does well, everything we've talked about in the past 2 days and the research that, for example, study does can play into the legal framework of shared responsibility.
Yeah, so for me, this has been extremely inspiring events. Because over the past 5 to 10 years, with a large group, we indeed worked on shared responsibility, and the core critical division in that work was between divisible and indivisible harm. And how you allocate responsibility really hinges on that distinction between divisible and indivisible. And many lawyers in that group really presumed that climate change, by definition, would be indivisible harm. That would create loads of complex legal questions, perhaps leading to such matters as joint and several liability, which raises questions in itself. So what I learned a bit earlier than today, but also today, is one, that our understanding of what is divisible and indivisible changes quite rapidly. If we would ask this question in 1992, at the time of the Rio Declaration, we definitely would have given a fully different answer than in 2002 and certainly in 2023. I still my conviction, listening to the discussions of yesterday and today, that there are loads of uncertainty that make it difficult to divide the harm and to attribute to particular states. But echoing what Freddie said, the main message that I take away from these discussions is that to a much larger extent than we knew 20 years ago, but even then perhaps 2 years ago, in a group of lawyers that discussed shared responsibility, we know that particular heat waves are only there because of climate change. And increasingly, we know that emissions that have already been committed historically can be attributed to particular regions, particular sectors, particular states. And that is all totally relevant, critically relevant for the possibility to bring cases against those states. And courts, of course, will still need to grapple with some degrees of uncertainty, but that's not alien to courts, and courts can well handle that. So the landscape really transforms quite rapidly. And what is really needed, and I think, Freddie, you said rightly so, that many of these insights are fully known to your community, but perhaps much less so to the legal community. So that transition really is quite critical to be made.
And you had a question for you. So the basis of a potential case in front of the SNJ will most likely be also the Paris Agreement. And the Paris Agreement that we have has got these numbers like pursuing efforts to limit the temperature increase to 1.5 degrees, but to hold the increase well below 2 degrees. And as part of the research, we've developed some pathways to 1.5 degrees to 2 degrees. We'd maybe talk a little bit about these pathways. Are you actually sure, can with these pathways, is it like 100% certain that we can stay within these limits set by the Paris Agreement? And also, you're part of the EU Scientific Advisory Board on Climate Change, and a report has been published that our European climate targets should be to reduce emissions by 95% by 2040. How does this play into these pathways that you've developed?
Yeah, well, thanks for these questions. Also from my end, first I want to express my gratitude for the workshop and the great discussions we had over the past couple of days. In my research, indeed, I develop low carbon transformation pathways where we see how the world can transform from where we are today to a sustainable future. In most cases, this involves very deep reductions in carbon dioxide and other greenhouse gas emissions. And it are these emissions and it are these emissions where we can, with relatively high certainty, which we can affect with relatively high certainty. We set targets on emissions. We affect activities that produce or do not produce emissions or avoid them. After that, the emissions will cause climate change. And while where there is no doubt, and it's unequivocal that those emissions will cause further climate change, there is, of course, as we have discussed before, an uncertainty range about how much exact warming we will get from one particular pathway. So what we get is we develop pathways and then we estimate what their temperature outcome would be. And for example, in the latest report of the Intergovernmental Panel on Climate Change, the IPCC, pathways then get grouped or categorized based on their likelihood of limiting warming to certain levels that are informed by the Paris Agreement. There is a 1.5 level referred to in the Paris Agreement. There is a 2-degree level referred to in the Paris Agreement. Just to give you an example, if we, as scientists, develop a deep decarbonization pathways that roughly gets to net zero CO2 emissions by mid-century, and that halves global carbon dioxide emissions by 2030. So that's kind of some of the most ambitious global emission reductions that we can describe from starting from today. We would get around a 50 or slightly less than that chance that we actually would limit warming to 1.5, and a maybe between 80 and 90% chance that warming would be effectively limited to 2 degrees. So this is really important to know that even if we follow a pathway now that is the most ambitious expression of what we can do in terms of mitigation, there is probably a 1 in 10 chance that even the very highest limit that should absolutely not be exceeded in the Paris Agreement will be exceeded. So that is a really important information. And then in your second question was about the European Scientific Advisory Board. Yes, so recently the European Scientific Advisory Board on Climate Change published an advice on what the 2040 target should be for the EU and the accompanying 2030-2050 budget. I'm a member of that board, but of course I speak here in an individual capacity. What we did there is we started actually from a global carbon budget, which is the global total amount of carbon dioxide emissions that we could still emit while limiting warming to 1.5. And we considered 1.5 because as in the report and the advice needed to consider had to be a scientific advice but for any advice, you need to make value judgments. And those value judgments, as advisory board, we wanted to make as explicit as possible. And we wanted to base them on expressions and on commitments of the EU. The EU has signed the Paris Agreement. The EU also under the Glasgow Climate Pact says that it wants to pursue limiting warming to 1.5 or resolves to pursue limiting warming to 1.5. And in that context, we started from a carbon budget that would limit warming to 1.5 with at least 50% chance. That is not great. And the main reason why we don't take a higher percentage is because where we are today. If we would have done the same exercise 3 decades ago in 1990, there would have been many pathways that give very high likelihoods that we limit warming to 1.5 and certainty that we limit warming to 2 degrees. But we are where we are today, and today we are already above 1.2 degrees of warming. That's very close to 1.5, and also dangerously close, I would say, to 2 degrees.
Maybe then a follow-up questions to the lawyers. So you just said that there are like probabilities of 50% to stay within 1.5, 80 to 90 to stay below 2. So how would you deal with it in the legal context? If science tells us it doesn't look too good to be within this limit, so how can we translate the wording from the Paris Agreement to science? So this is what science tells us enough or not?
Shall I? Okay. So yeah, I think one of the main messages of this workshop was that we need to, I think, I can only speak for lawyers, and of course, it's my personal take home message that we need to accommodate law to be better responsive to probabilities, because of course, international courts refuse to speak in the language of probabilities. Fact-finding statements are not made based on probabilities. They courts, judges are instructed to look for certainties, to become certain about what's happened, about the facts of the case. So this is a huge challenge, how we can approximate these two social words, like the expectations of law, how we can approximate them to the scientific realities and scientific probabilities. So I think one of the main missions of this workshop is that how lawyers can think in different ways, and whether we can a bit relax rigid legal doctrines to better fit the factual realities. And of course, I think it's also important to really make a sort of expectation management of lawyers, and especially for courts, what they can realistically expect from scientists. And if they can only get probabilities, then I think we reach the point where law must be responsive to these changes and must be more embracive of probabilities.
Yeah, so let me add that we have been looking at this from a rather one-sided angle of litigation, which of course is intellectually interesting and also practically relevant if you look at the increasing number of cases. But of course, our main hope should not be on the role of law in litigation, but rather on the role of law in the prevention side. So much of the developments to which Joeri referred to eventually will not play out in litigation, but hopefully in improved regulation and in interpretation of existing commitments. Now, I guess historically our hope that international politics, ex-ante regulation really follows quickly. New insights of science should not be put too high, which we disappointed more than once. But of course, the more clear and the stronger the consensus becomes on the scientific front, the stronger the impulse becomes on for ex-ante political regulation and improvement of something beyond theirs.
Yeah, so I mean, I guess that was also one of the questions. Well, why we have political processes, we have the science that is much stronger than a lot of us lawyers are probably aware of. But then, what would be the added benefits of going to an international court? Like, what, what you see the goal for that. And then maybe additionally, we talked a lot about, okay, we need to translate all of this into some kind of actions, obligations, prevention, but not only. I think we've also talked about adaptation and how to address the harm that's already been done, because we're not anymore in a space where we will prevent all the harm from climate change. And, you know, whose role is to be translating, and is translating the right word, to translating the science to law and the law to fit the science? Is it the judges, policymakers? Is it us? What kind of roles do we see? This is kind of an open question that we can then take also.
Yeah, so 2 points. So one is it all depends on the question that you put before a court. So if the question before a court is to adjudicate on a particular harm to a particular person in a particular time and place, due to a particular plaintiff, then the science necessarily will play a role in determining causation and all of that, and attribution. Looking to the ICJ, these will not be the type of questions coming there anytime soon. So the role of that type of judicial proceedings for me lies mainly in articulating, clarifying the nature of and the contents of obligations imposed on states. So science can help because it allows the court to be slightly more precise on particular obligations. But this really, on the larger scheme of things, is one small cog in a much larger machine. And looking historically, there have been quite a few cases where the court has clarified obligations. In the result of the Israeli occupation, to say one thing, that have not made one has made no difference whatsoever on the ground. So it can put some additional pressure on the political process. But let's not put our faith too high in what the courts can do in the overall process of climate change prevention. Maybe you're slightly more optimistic.
No, I don't think, unfortunately, I'm more into optimistic. I would say if we look at the domestic level, so if we look at all these pending climate lawsuits, I think there is much to be done by both parties involved. I mean, as Freddie also already mentioned, that the scientists can help us with communicating their results in an accessible way, in a way that a layperson can also understand, and also see a definitive role for acting counsels in the cases, and in terms of offering workable, creative framings for the courts that could bring out the legal relevant aspects of all the climate data that scientists are now providing to us. So I think the task of integrating climate science into law, it's an epistemically very arduous task, and it cannot be left only to the court. So there's a role for councils to play in sort of experimenting with different framings, and also the academia, I think, is a large role to play, both in terms of helping better understand what science can deliver, helping making legal sense of climate data, but also sort of mainstreaming the idea that science-intensive adjudication is totally normal. It's not off limits for the courts. I think courts usually are very cautious, and they may have the right reasons to do so. So I think the whole wider public community and the public as such could also help in terms of sending messages to from the society as such that we expect the courts to act, that we think that it is a mainstream thing to do to respond effectively to the climate emergency. And I think, and also I think we need to send a strong message both from as academics, but also ordinary persons, that making decisions under uncertainty is again totally normal. So we should encourage the courts to be willing to understand these complex and highly complex and to some extent uncertain matters, and to make decisions under uncertainty.
Yeah, and maybe add one small thing. So one takeaway that I took from this workshop is the multiplicity of pathways that exists to get from A to B and to achieve a particular production. And the fact that there is, let's correct me if I'm wrong, that there is generally no scientific basis to differentiate between these different pathways. So whether you reduce in sector A or B or C, that eventually that has to be a political question. And if it is a political question, then the courts also cannot do this. So there is a connection between science and the court, because to the extent that science would actually provides a stronger basis for suggesting pathway A or B is superior to C or D, then they will be relevant to the court. But as long as it cannot be done, the courts will probably have to play that ball back to court.
This is correct. In as far as the only question asked from science is how to go from A to B and reduce emissions. Now, fortunately, there are also other things that are asked from that transition. And there science can again inform about which option is more desirable than another. And allow me to give an example here. A clear example is that in the Paris Agreement, also many national governments and the EU emphasize the importance of sustainable development. Now, and that's a good example to bring our emissions down from where we are now to zero. We can do that in very sustainable ways. We can do that in very unsustainable ways, in very unjust ways, in ways that exacerbate inequalities, in ways that are environmentally detrimental. So there, as a scientist, once I have the information that society is not just interested in reducing emission, but doing that within a sustainability framing, then I can also inform whoever is interested, courts, for that reason, that pathway C and D of the option space might not be advisable to follow, given these other objectives. So.
And I think if I may add one thing, you said that if we bring a case to the International Court of Justice, it might not make a huge difference. But I think what might make a difference is if in that court science is interpreted in a particular way that will inform how then domestic courts and other courts can inform science, and that has quite often more power, and I think that is something why the International Court is important, rather than just per se in its sort of in its own.
Thank you very much for all these contributions until now. So I would now like to open the floor to questions or observations from the audience. It can be both online and on site. If you're here and want to ask a question, we have a microphone so that the people online can hear you. It seems like you are burning to ask a question. Is that right?
There's a sharp eye for interaction. Yeah, sure.
Yeah, it's so intense interest from your side. I'll let you open.
Thank you. I was just very much enjoying your illuminating remarks. That must have been burning, I guess. But at the same time, I do have a question, especially tying into the last bit. So the division, so to say, between courts and politicians. Because I tend to agree with Professor Nollkaemper that at the moment that there are different pathways, they all lead to the point where we want to get. We need, of course, a democratically legitimate way to assess which one is best. But at the moment that you can establish that a particular policy or activity is incompatible with every pathway, and I think increasingly, such as starting the exploration of new oil fields, it becomes increasingly clear also from a scientific point of view that this is not compatible with what we've already agreed upon to establish. So I was hoping to work towards a question. I'm afraid it's just going to be this remark, but I do believe we as lawyers shouldn't be too modest in where the law can start to recognize legal obligations even without the policymaker acting there.
Yeah, and if I can build on that, then and translating it into a legal question for lawyers, but also for the scientists, is whether you have discussed in that the role of due diligence obligations within the no harm rule under customary international law, given that I also agree that probably that's the pathway that would have more a dent into an adjudication proceedings under the ICJ. Yeah.
Any other remarks while I'm handing up the mic?
Okay, can I say two small things in response to these two excellent questions? So on the first one, Yeah, so my slightly critical comment or reserved comment on the ICJ was mainly induced by the fact that the procedure now will be advisory proceedings. So there will not be a question whether policy A or street B is or is not compatible with a particular obligation. But of course, once you are in a different procedure in the domestic court or in the European Court of Human Rights, and indeed the question is whether energy policy of state X is compatible or not, that is very well possible to answer that question quite firmly. And then, of course, the improved quality of science is very relevant. So personally, I would invest my hope rather in domestic courts and perhaps in human rights courts than in advisory proceedings in the ICJ. But I fully agree that there's a clear limit beyond what we can say that policies are simply not compatible with these obligations.
Yeah, that's where law kicks in, definitely.
Definitely, yes. And that feeds directly in the second question, because indeed for most, at least at the interstate level, the due diligence obligation not to cause significant harm would be key. And again, here the interface with science is critical, because that obligation has to be triggered at some point by a risk or a threshold of certainty that a particular harm will occur. So once the evidence for this threshold becomes more firm, the obligation quite clearly applies, and then it becomes a matter of what diligence is due in a particular context. Now that depends on a variety of contexts, including capabilities, but also scientific information on what is needed. So here again, and we discuss this quite extensively, the advance of science actually can be relevant to fill in and make more concrete what diligence is due in a particular case. Maybe others.
But I think we have discussed the due diligence question a lot with the view to the future. I think I would have wanted us to discuss more about the harm that has happened already and is happening already now, and is killing people and destroying livelihoods. And I think we didn't get as far, very far, in where exactly, how exactly can you pin this evidence that we certainly have. But of course, it's a slightly more messy evidence than having some future temperature pathway is sort of real impacts to real people that have all sorts of different vulnerabilities and all sorts of other things going on. But I think there is still due diligence that is probably breached, but that to identify that and to see which exact branches of science to bring together is something there where it's not quite so clear right now how that looks. But I think it's something where actually we should really try in this linking with law and science, because where there is currently a complete lack of ambition is in climate finance, in sort of with respect to reparations. And I think that is something where this collaboration and where law and the courts could play a really important role, but where we maybe have to do a couple of more workshops to identify exactly how, but
yeah, maybe and yeah, with the danger of being totally off track here, of course, as a scientist commenting on a legal issue. I also want to connect it to the probabilities that with which we will reach certain levels of warming under the pathways that certain national governments are assuming that they are pursuing with their efforts. And I also want to be a bit self-reflective there in what the scientific community considers to be a good considers to be the default assumption for a 2-degree pathway. I mean, as scientists, we don't, I mean, we can pick any number. So established practice has picked a number. Practice has picked for a while now a 2 in 3 chance. A 2-degree pathway has been described over the past decade as a pathway that has a 2 in 3 chance that warming is effectively limited to 2 degrees. Now, if you put that in the context of harm, and that's the thin ice here. I mean, what is it defined as harm? But the IPCC clearly shows that between 1.5 and 2 degrees, there is a difference between some coral reefs, some tropical coral reefs surviving, and all coral reefs having died back. Between strong impacts for vulnerable communities around the globe, and at 2 degrees, basically the undermining of their possibility for sustainable development because of the sequence of extreme events and climate disruption they would be subject to. So the second part was always the 2 degree level, which in my head as a scientist sounds like harm to me, for potential harm at least. And so if there is a 30% chance, or even in the more ambitious pathways that we consider, and we call 1.5 degree pathways, there is a 1 in 10 chance that harm can be achieved. Yeah, it's a clear. It really ties very nicely in my head to questions of how should it be prevented and what is the due diligence required here.
I see further hands. So hand over to you.
Yeah, thanks. I one question for Professor Rogelj, because I think the point with regards to the risk of higher temperature levels is a very important one that is really badly understood by a lot of people, including litigators. I think actually one of the problems is that there's very little, or it's actually difficult to find the information of what does a 50% 1.5 budget mean? How high are the likelihoods of higher impacts? Because we do see a lot of discussions now on, well, you know, probably if on current policies we'll get to 2.7. So talking about 3 degrees impacts are no longer relevant. Whereas if we listen to what you just said, it's very relevant to think about 2 degree and even 4 degree impacts, because there's still a likelihood of that being achieved. So doing what might lead to 2.7 or lower might actually also still lead to, with a certain chance, to 4. But that's like what the likelihoods are on the basis of the most recent knowledge on climate sensitivity, etc. It's very difficult to, I mean, there should be like maybe an easy website like you know, like your website, Friederike, that says, okay, this is these are the rapid impact distribution. There should be a very straightforward website that says, well, if you read this, then it actually still means X% chance of that, because it's so crucial, but it's so buried in all the reports. Well, this is, I probably could have expressed this shorter, but I just want to stress that that's incredibly important. I had one comment with regards to due diligence, and that was, I think, yes, there's a role for science to kind of like do the science that allows lawyers to say, what is due diligence? But there's also a role for lawyers to say, well, due diligence requires for states to do the research. Because what we know and what we don't know is often a result of who gets the grant on what. Huh? So we can say like, oh, we don't know, but actually we have an enormous pool of extremely smart people that if they get the right money, they'll give you the answers. So I think the whole thing of due diligence is an obligation to investigate on the side of the state. So they can't hide behind ignorance if there's not a paper written about it already. The basis of scientific knowledge is so broad at the moment that there is so much we can know that is not known yet, just because there was not a specific person writing that paper. And I do think as lawyers, we need to be aware of that at the moment, and need to think about what this duty actually encompasses. And it's not that we already know that the paper has been written, but that we know that it can be written if we put the resources into it.
I'm not quickly responding on your first point. I fully agree that that information might be difficult to find, but there is a recent paper 2 weeks ago published in Science that gives you these distributions for current policies, for NDCs, and for different interpretations of these credible targets. That's of course good for now. NDCs and policies are expected and hopefully will be improving and changing over time. So it's not a permanent solution. But for now, there is at least a first opportunity to get insight in that. And I take your suggestion actually to maybe make this more easily available and maybe updatable. In the context of the UN Environment Programme's emissions gap report, we intend to update these analyses, and we update these analyses on an annual basis, but they also are represented in very in very synthesized ways in the report. So maybe if you're looking for what is the likelihood that I still meet 4 degrees, that exact information is not there because, well, it has to be summarized in a smaller paragraph. So
can't you put it in a table?
no, it can't exactly. It can be made available.
Table as an appendix in the back.
And therefore, it's really good to know that kind of information would be absolutely useful.
It's crucial because it's complete. The whole scientific legal community doesn't get this. They think, oh, it's a 1.5. So if we do this, it's 1.5. The fact that it says 50% to 1.5, it doesn't really. You have to make it much more explicit. They don't really get what 50% is, and the fact that 50% 1.5 might actually mean 3. Nobody understands it.
So on the second question, I must say, as a dean, I find the idea that there might actually be an obligation to favor particular research over other research is quite tantalizing and very, very interesting. I mean, of course, we can have an obligation on freedom of research and of access to research, but the idea of obligation for states to finance or fund or facilitate otherwise particular types of research is a very interesting one. Of course, the point is that there are multiple competing fields. So people from health or disarmament might say the same thing.
Let's make it very concrete, right? So there's a whole discussion on how much should a state do.
Yes.
And now we have this report by the scientific advisory board. But you could argue that there was already a legal obligation 10 years ago for every country to do that report, and for every country to say, what is my fair share and what is the maximum level of ambition that I can achieve with regards to emission reductions on my territory. That's my legal obligation. Now we have a report at the EU level, but is there not an obligation for every state in Europe, for instance, to have that report on the national level?
No, sure. I mean, the legal construction will be that if you have a due diligence obligation to prevent a particular type of harm, you can interpret it as meaning that you should investigate or make the investigations so that you get the data and information that you need to make that assessment. So this is common knowledge for the connection between that obligation and environmental impact assessments. And indeed, there's only one step further to say, well, leave aside environmental impact assessment, simply do the research you need to have the information that will allow you to see what steps you need to take. I think it's a very interesting argument.
Would that work across borders? Because could that argument be used to make the obligation clear to global north states to invest in capacity building and research capacity building, for example, so that we can build early warning systems or so in the global south, or not?
I wanted to say something, but I won't.
No.
I see that people have been patient.
You answer this question.
No, but I see that people are waiting very patiently online, and in the interest of keeping it moving, I'd like to call on, could you, I can't read this, so I'm sorry, but Mohammed, if you could unmute yourself, please, if I think the room can hear you.
Mohammed, are you there? You are free to ask your question.
Has to unmute. He asks you to unmute him. Yeah.
I think there's a faint sound coming out of this speaker, but
Oh, wait.
There it is.
Yeah. Were you by any chance talking already, Mohammed?
Maybe you can put the question on the chat and then you can read for us.
Yeah, I'm sorry. Could you put the question in the chat? Very sorry about this.
I hope they can hear us.
We can have another round here. Yeah.
Hi. So my question goes, I guess, for everyone. So one of the challenges is implementing the principle of common but differentiated responsibilities. And I wonder to what extent the scientific expertise can help us in devising some sort of fair, including some fairness element into this, or yeah, there you go.
So we discussed fairness. It was quite controversial, I think, on the table. You want me to give it a go?
I can give it a go. I think I will take the example of what we did with the European Scientific Advisory Board on climate change, where indeed scientists had to estimate or look at what would be a fair contribution, and so what the EU should do, and then also what the EU can do or could do, the most highest possible ambition. So what we came up with is that we can inform this, but only if we have a clearly stated theory of justice or justice principles in the beginning. What we did with the advisory board is we went to EU legislation to see some of the principles that are being explicitly mentioned in EU law. The polluter pays principle is explicitly mentioned in the European climate law. The equality principle is another principle that is mentioned in EU law. Once we have these principles, we can make choices of how to quantify those and understand the implications of these principles, and that allows us to give at least an indication of what would be a fair contribution, or in light of those principles. In the report for the EU's 2040 targets, we found, however, that no matter which pathway between 2030 and 2050 we drew, that was still technically feasible or technically possible, we would actually, or the cumulative emissions in that period would actually add up to a fair contribution. There would always be a shortfall, or better said, the cumulative emissions would always exceed the fair contribution that we would have quantified. And so that is also something that we highlight in the advice, that the deep reductions that are being advised by 2040 represent a shortfall and should be accompanied by further measures, be it finance, partnerships, collaboration, and so on, to ensure that further reductions are achieved outside the EU as well. So it's a package.
Yeah, that's one thing. So we speak about common but differentiated, and the question is on what grounds which it differentiates. I mean, fairness angle is one, but if it would be based on historical contributions, of course, then scientific data have quite a bit to say for differentiating between particular states, particular groups of states. So in that sense, I think the also discussions we had actually are very helpful for understanding and making more concretely what common but differentiated can mean.
Yeah, so one of the major outcomes was that scientists can quantify basically anything, and you need us lawyers to give some legal benchmarks to discern some sort of legal requirements that they can put, they can calculate them, and then this is how we can potentially approach interpreting notions such as fair share or equity. But I also see that these fair share applications are infinitely complex, and they may be very, very complex for international courts to use. So there's still much work to do to make these extremely complex calculations persuasive for scientifically non-trained courts.
Yeah, my question is about on the point where you left off. Just so the thing is that I can imagine a situation in a courtroom where the scientists are giving some facts and the lawyers are trying to find a response to the question of a law. So then it becomes a rivalry about question of fact or question of law, and the question of facts may become the major part of the case, where the judges now need to understand which science is the best or giving more accurate results. So the question is, how much science do those judges need to know? how much they need to know. Should they be able to read should they be able to read the blue files? Should they be able to have an expertise to the level that they can differentiate? It's not about only differentiating the responsibility, but also differentiating the best or good research from bad one, or let's say more accurate one. Thank you.
Maybe just to intervene, I think this online question kind of links into your question as well. So I'll just read it because I think it's Kata's cup of tea, so to say. So it would be logical to look at the ICJ jurisprudence. How do they evaluate scientific facts? What do you think about the court's approach in nuclear weapons and the whaling case?
Yeah, I think the court has some very disappointing decisions in its history. Of course, in environmental disputes, the Gavčíkovo case or the Panelists dispute, the parties supplied scientific information, and the court either did not evaluate it at all or dismissed all evidentiary submissions by saying that none of them is certain enough in order to be appreciable legally. But the whaling case, in my view, is a bit different. I think it's the way in which the members of the International Court of Justice actively cross-examine the experts and actively try to make sense of the expert input in the sort of reasonableness test. And so the main question was whether the Japan's whaling program was scientific or not. And then both sides brought experts to the court, and the scientists tried to explain and try to argue that there are some defining characteristics in the scientific method, what makes science. And of course, these two sort of scientific narratives collided. And the court, instead of being caught up in this endless debate of which side is better founded scientifically, it sort of created its own path to the problem. And it said that allegedly research project, which the implementation of which is not reasonable in light of its stated research objectives, it's not reasonable. And what's not reasonable cannot be scientific from the viewpoint of international law. And I think it's a very nice sort of example of how international courts can actively deal with scientific sides of disputes. I think there are some sort of points of translation on the interface between law and science, which international courts can confidently approach and interpret. And I think the concept of reasonableness is such a concept, because appraising reasonableness is an inherent function of courts, and the international judges are trained in appraising reasonableness or consistency or coherence of certain schemes. And the reasonableness and coherence and consistency also carry some scientific meaning. So I think these sorts of, in my view, this case provides a nice example of how we can find some sort of concepts around which we can work some multidisciplinary cooperation around. And these sorts of legal concepts, which are inherently scientific at the same time, also gives an opportunity for the court to retain its control over the adjudicatory process, but also having a close look at the scientific aspects of disputes, the scientific evidence, but at the same time crafting a judgment for which it can take responsibility for. So which was not entirely outsourced to scientific experts, because that would raise other types of legitimacy issues among lawyers.
I think one quick remark to your question of how much science do judges need to know. I think in climate science, actually, we have this unique situation that we have the IPCC. We have this body of where actually the whole community comes together and assesses what is the state of the art, what are meaningful methods. And so as a judge, you don't need to be able to judge that yourself, but you can see, okay, pick experts who are from that body and not paid by RWE. And it's not hard to find out. That's not a secret. But I think that this body exists and what role it plays, that is something that judges need to know. And that actually in the climate science community makes it very easy to find out what is good science, what are accepted methods, and what is not, which is a hugely unique situation and should actually make it much easier than in other maybe scientific fields where such bodies do not exist. But I think we all, and that includes judges as well, suffer from having been exposed to a narrative for the last decades that, oh, climate science is super uncertain and is a super special science and everything that, which is not true. Of course, there's uncertainty, but so is in every other scientific field as well. It's not special in that sense. It's actually special in a much more practical and useful sense, but that is something that is absolutely not understood, neither in the legal community nor in the general public. And I think that's something where everyone can play a relatively, well, where we don't need to do new science or make complex calculations, but just communicate this fact and tell better or different narratives than the one we have been exposed to for the last decade.
Great, thanks so much. It's been super interesting. Ingo Fenske is my name. I had a question to the scientists, first about the human factor in the modeling, how you deal with that, with present and future choices that we can or cannot make. Would they only be assumptions? Would they also be modeled, and how that comes in? And a question to you and perhaps the group of these 2 days. How have you discussed what have you learned about the precautionary principle and the interactions between science and law? And connecting that to the first question, it's a bit funky perhaps, but I mean, usually is understood to, roughly demand caution in the eye of scientific uncertainty. But a lot of the projections and pathways, of course, depend also on future choices and action. Is there any opening to say, also in light of what André Nollkaemper said at the beginning, we haven't been very good at learning in the past or acting in light of knowledge. So would there be a precaution about our future selves? And would that impact the demands that would arise in the present? Thanks.
Thanks. Christina. My question would be, we have discussed how law has to adapt to science on the one hand, and we have also heard what science can do for law, at least challenges what science should be better to serve litigators. My question would be the other way around. What are the shortcomings or maybe even pitfalls in the law at present? And I'm thinking, for example, of if you think of the Paris Agreement and its limitation in the nationally determined contributions to the territory of the individual state, if we discuss international agreements, for example, and we all say we want to stay within the Paris Agreement commitments in terms of mitigation, obviously, that only limits us to our own territory, so we happily can emit outside of our own territory, as one example, where law, for example, is falling short in regulating in the way that you would like. And if we speak about the European principles that you said you used as the basis for the report, European law obviously is also very navel-gazing and thinking of what happens within the European Union. And if you take constitutional principle at any point in time, primacy and direct effect would beat the precautionary principle in the light of in the eyes of the court. So what are the pitfalls? What are the shortcomings of the law?
Can maybe respond to the one how science deals with things not yet decided and that are definitely in the societal realm. One way that science deals with it is by creating scenarios. Scenarios that represent the choices that we can make today, or that can make futures where we don't make a certain choice, and then futures with lower emissions, and therefore represent futures where we have made important choices and we've implemented policies. The importance of that is that this also needs to be communicated as a choice, not just as an uncertainty. We don't know how much warming we will get. We know clearly in a what-if sense what we will get. In addition, something that we also discussed during this workshop is whether emissions today and the consequences that they already imply, irrespective of what will happen to our emissions from now on, can already provide a sufficient floor of impact or harm to be convincing in courts. So then you kind of take away the choices that you still can make, but just it's the consequences of the actions that you have already done. So that's one. On the last question, gaps in laws, I will leave to the lawyers. But one regulatory option to deal with what you described and what we in the literature know as leakage. So the fact that you can reduce your domestic emissions, but just import products that have been produced with very high emissions elsewhere, is something that could be dealt with through carbon border adjustments. So basically a tax at the border that taxes products that have been produced either by, in this case, as a in a very polluting way, in a very carbon polluting way, but a similar logic can be applied to other types of pollution or other types of values that we set, or objectives we would set. I'm thinking about slavery or child labor, where the tax would basically be infinite because the products we wouldn't want to import them in the first place.
But that's a market-based mechanism that tackles the effect and not the obligations. So the problem is if your obligations, if your mitigation obligations are limited to your territory, what you're suggesting is a market-based mechanism to sort of deal with the effects, but that doesn't change the basic legal obligation to either reduce and mitigate or to not mitigate. So if I'm producing my hydrogen in North Africa as Europe, well, potentially it's taxed at the border, but I'm still producing it there. Yeah. So I think it's a slightly different context, the CBAM or whatever context you want to suggest.
It definitely is, but on the point that you're trying to address, I think I have to leave it to the lawyers who might have a more informed opinion.
You want to go first on science? Katalin, in your question?
The scientific part?
No, I think Joeri has answered that.
Okay.
Shall I give it a go?
It's a big question, the pitfalls of law.
Yeah.
You want to go first?
Yeah.
I have 5.
Okay. Okay. My starting sentence would have been that we have nothing but limitations, especially in climate law, and especially in other fields of law, which now we try to utilize in climate litigation cases like human rights law and environmental law and customary international law. We do not know so many things. What is the content of states' obligations, either under the European Convention on Human Rights, what are the climate obligations in terms of, what are states' positive obligations in terms of climate mitigation adaptation, we just don't know. So that there are lots of unknowns in the system, like legal uncertainty. We don't know the content, how they play out in the context of climate change. And then we have massive limitations in the written law, in the conventions that you just mentioned. I could also, refer to the limited rules of standing in EU laws, which prevented all the EU climate lawsuits to proceed. So I think we would not have this major boom in climate litigation if the law would not be so manifestly ill-suited. And we have so many limitations. I'm very curious what your thoughts are on this matter.
Yeah, I was more wondering also from the perspective of science. You said you used the legal principles. What else? Where did you find limits in that? So you used the precautionary principle and combat differentiated responsibilities and whatever, no harm, and you name it. And I'm wondering, these jurisdictional and territorial limitations is, of course, the obvious first thing that comes to mind. So the fact that I never think, particularly from the perspective of the ICJ, where I personally don't have a lot of faith, but more domestic and regional or national courts. And there's, of course, the first point of limitation. But I'm wondering what other limits you feel, what else would you need in terms of you set out clearly explicate the normative choices. And I'm wondering, did the law satisfy you in helping you to develop these normative choices, and where would you have wanted different choices? Not so much maybe more detail on what could fairness mean, but what else would you need to better do your job in providing the science that then in litigation or in program in ex ante lawmaking regulation could be picked up?
Yeah, so I will just give one example of where we didn't find much guidance, and therefore we had to make several assumptions. And that is, when does responsibility start? Does it start in 1990, when the first assessment report of the IPCC was published? Does it start in 2015, when the Paris Agreement was adopted? Does it start whenever you started emitting? That was something where we clearly did not find clear guidance, and therefore we just made different assumptions, and we showed the different cases for the different choices that we made. One example.
I think another example from a different field is responsibility for vulnerability, or how to treat concurrent causes, because we can make relatively easily the assumption, everything else being equal, how much larger is the harm because of climate change. But is that enough, or how do you treat the other causes of the harm? So, for example, when you think about the Pakistan floods happening last year, climate change did make the rainfall more intense, a bit hard to quantify exactly how much, but also the beautiful British water management system caused a lot of harm and led to a lot of, especially countryside with lots of farmland and poor housing being flooded. That is also an important factor in the actual harm. So there are lots of other, of course, concurrent causes. So how do you treat them? How do you look at them? Are they important for what, under what circumstances are they important? I think that some guidance on that would be great.
Would it be, because you did you talk about the 5 limitations?
No, but I reserve them for some other time.
Okay, that's good, because there are also some online questions, and it might be nice to give them a go as well. So we have a question from Murray Scone, hi, about the divisibility of responsibility. So how can courts distinguish the responsibility for harms that have stemmed from unequal historical developments affecting vulnerability, as opposed to emissions? So colonial oppression, marginalized and vulnerable communities who suffer more harms from the same event, and privileged communities, etc. Thanks. So very good question. And just to add a second question from Marina, also with regards to attribution, or somehow related to attribution, how can scientific uncertainty in attributing climate impacts be appropriately addressed in the context of adjudication? How can we better utilize scientific attribution to establish causality and quantify responsibility of the actors involved in climate change aggravation? These are like the questions we formulated at the end to work further on, but maybe you already have some preliminary reflections.
You want to give it a go?
I think on the, I don't have an answer for the first question, but Dennis has. Well, you wanted to answer my question, right? So maybe you do.
Yeah, no. So I had, okay, so one reflection ties into something that you said, like, vulnerability, and I think the answer to your question, like, why are there not more cases about all the harm that's already being done in the global south? That was part of your question earlier, like, those are the people that are really suffering, like, why is, and I think part of that answer is that, so there are 2 parts to it. One, we have a very imperfect system of climate litigation right now that looks at the human rights of the person in the jurisdiction where the harm is being caused, which is not in the global south, it's here. So that's very imperfect. And that leads me to the second point. And I was kind of also, I think climate science, and I've been studying this as a lawyer for a while now, I find it a really fascinating part of science because it's imaginative, right? You have these scenarios, you think into the future, you think of what can be. And I think if we as lawyers look at ourselves, we are a very unimaginative group of people. Yeah? We don't think in scenarios, we look backwards, we look at what has the judge said. And I think those are very uninteresting questions actually, because this is a new problem and the judge still has to deal with the new problem. So I'm actually, that's part of, I think, the answer to some of the questions that have been raised here is that I think the problem here is not that there's not science that can be used in courts. I think if you look at what the problem here is that we should solve is that the lawyers should think more in scenarios, become more imaginative. There are these principles that are in the law, And we should think about what are actually consistent interpretations of all these different tools that we have in these different areas of law, and how can we imagine within the current constructs that we have and within the limitations, and we can't invent new laws, right? We can't invent a global treaty which actually would achieve justice, but still within the confounds that we have, how can we imagine certain judgments and certain certain judgments and developments taking place. So it's more like, we need lawyers building scenarios, basically. Yeah? So I think actually that would be my main kind of like comment and thing that, and call to the legal community, because, don't look at the actual climate scientists, understand their science better, because there's, as Friederike, as you said, it's there, right? Don't think the problem is that there is not enough of it. Lawyers need to better understand what's already there and need to start looking at their own tools on how to better utilize the law to kind of, as is currently done. So I hope that answers a bit to what you, were raising before.
Yeah, so the question on attribution and how to better use attribution, I think it's really, don't focus on the difficult cases. So I think really there are some harms that are very, very clearly attributable with what you can't necessarily give us a certain answer on the exact number, but you have absolute certainty that the harm that part of the harm or part of the damages or whatever is caused by climate change. And there are lots of examples, and I think that's one thing. Just focus on these and not on the ones where we don't have data or where it's just climate change is not playing a big role. So that's I think the main thing to sort of to not say, okay, let's just assume attribution and not deal with the science at all, which is what currently has happened in the damage cases, and most of them have not actually gone into the evidentiary phase, but probably that would have then been quite problematic. But focus on the cases where the harms are clear, and I think the scientific community can probably do a slightly better job in saying very clearly where we have these clear-cut cases, and where we have certainty that harm has been caused. I think we have also, as a community, been very conservative in how to communicate this, and always communicate within sort of uncertainty limits. And the IPCC has the confidence language where sort of one of the categories is low confidence, which sounds as if we are not very confident, but actually low confidence, if the IPCC has low confidence that something has happened, we are pretty sure it has happened. We just have some limitations in the methods and in the quantification. And I think there's a real translation effort that we can do, and that will also then make it much easier to use attribution and other things.
So thank you very much. Are there final reflections on this from the other panelists? Because if not, then it might be time to close. So thank you very much to the audience for the interesting questions, to all of the to all of the workshop participants. So it's been an excellent 2 days. Special thanks to the four of you for your willingness to continue these discussions at this final afternoon while we're all a bit tired. And thank you to our PhD researchers that stimulated our discussions and worked hard to make this a very good experience for everyone.
Thanks to you, Natasha, for convening and hosting.
Yeah, thank you. So let's give a round of applause.